Knowledge is power. Information is liberating. Education is the premise of progress in every society, in every family. We have gathered here for the valedictory ceremony of 12th Nani Palkhivala Taxation Moot Court Competition 2016. I request you all to raise for the invocation song. I call upon Anantharaman, a 4th year BCom LLB student, to invoke the blessings of Almighty.
Sakala jananam shreyo bhuyat Sakala jananam shreyo bhuyat Sakala jananam shreyo bhuyat Sakala jananam.
Thank you, Anantharaman. Now I call upon Vikas BM, a 3rd year BLLB student, to present the welcome address.
Thank you, Harini. Good evening to one and all present here. It gives me, Vikas, immense pleasure to have the privilege of delivering the welcome address of the valedictory function of the 12th Nani Palkhivala Memorial Tax Moot Court Competition 2016. It has been a weekend filled with intellect, wisdom and eloquence, and to top it all off, we have 3 of the sharpest minds of our country as the judges of the final round. Mr. RSVS Pawan Kumar is from the 1987 batch of the IRS Income Tax. He has been in the Income Tax Department in various capacities in the areas of investigation, assessment, administration and vigilance. He was involved in the investigation of cases of the security scam of 1992 and a large number of seizure and search and seizure cases. He is presently working as a Commissioner of Income Tax Exemptions in Tamil Nadu and Judiciary and supervises the administration of income tax provisions relating to charitable and exempt organizations. And this is something interesting that has been pointed out to me, and I've asked to share this with the audience. When our institution, our university, invited P.R. Ramasubramanya Raja, the chairman of the Ramco Group, to be a part of this event, he replied via letter to our Vice Chancellor, and he thanked us for the invitation, and I am quoting from the letter. He says, "I am also happy to receive your invitation for the valediction of the above competition program taking place on 3rd April, for which you have invited doyens of the income tax, especially Shri RSVS Pawan Kumar IRS, Commissioner of Income Tax Exemptions. In my opinion, he is a large-hearted person who interprets law to help the honest and genuine taxpayers. It is very difficult to find such a person in the Income Tax Department. I am glad that you were able to get him to speak on this occasion." I think that exemplifies the character and the nature of the man we have leading the jury today. It is a pleasure to have you here, sir, and we wholeheartedly welcome you. Mr. Arvind P.Datar is someone who does not need introduction to tax students, especially to mooters. He is a senior advocate with an experience of over 35 years and is an expert on constitutional and tax law, having authored books and articles on both fields, which I'm sure most of the participants have referred to in their preparations for this competition. He has argued in various high-profile cases in the Supreme Court. He represented the Madras Bar Association in the Supreme Court in the case where a 5-judge bench of the Supreme Court struck down the constitutional validity of the National Tax Tribunal. Mr. Datar has also been in the limelight recently as the advocate representing the Securities and Exchange Board of India in the SEBI vs. Sahara case. It's a privilege to have you here, sir. We are completely honored and we wholeheartedly welcome you. Mr. N. Venkatraman has been a part of the Sastra family for a while now, and he has proved himself to be a valuable guide, mentor, and an exemplary source of inspiration to all the students of Sastra University. A senior advocate with over 25 years, he has argued in multiple and various high courts of the country, and he has argued high-profile cases in the Supreme Court. Mr. N. Venkatraman represented Vodafone in the Commissioner of Income Tax versus the Vodafone SR South in the Delhi High Court, and also represented Wipro in its foreign credit tax dispute with the revenue, which I think was evident from his line of questionings to the participants. It gives me immense pleasure to once again welcome Mr. N. Venkatraman on behalf of Sastra University to our campus. I would also like to humbly welcome Honorable Justice Nagamuthu to our to our event and to our campus. You have blessed us with your presence, sir, and we cannot thank you enough for making it to this event. I would also like to humbly welcome our Vice Chancellor, respected Professor R. Sethuraman, whose constant blessings and guidance have always been a source of strength. Further, I'd like to welcome our Dean of Planning and Development, Dr. Vaidya Subramaniam, our beloved Head of the Department, Dr. Abhishekara Raju, I would also like to welcome all the special invitees who are present here, my fellow students, and last but not the least, the participants from various institutions all over the nation who have made this event a success. Thank you very much.
Thank you, Vikas. Before we move on, I request our beloved HOD, Dr. P. Ravishekar Raju, to give away the mementos for the judges of the finals. Now, it is time, ladies and gentlemen. It is indeed an honor to call upon Senior Advocate Shri Arvind P.Datar to deliver the valedictory address on this occasion.
I must first apologize to Sastra University for taking so long to come here. It just happened that whenever Dr. Subramaniam called me, Vaidya Subramaniam called me, some reason or the other I could not make it. And so this time when he said that I'll have to judge the finals and also speak, I made it a point to be here at any cost. And I think I'm really glad that I came here. Now I regret I should have come here a couple of years earlier as well. Before I give my lecture, I must congratulate all the people who participated in the mood competition. When I see all of you, I have no doubt, and I don't say this to flatter you, I have no doubt that there is still Achhe Din will come for the Indian legal fraternity. I only hope and pray that most of you get into litigation and don't take corporate jobs and leave the profession. Please. There's a lot of scope, a lot of necessity, there's a dire need for very competent counsel. Now coming to my lecture, I first came across Mr. Palkhivala, Nani Palkhivala in Bombay in 1973. I was a student of the Ruya College and we have a sister institution called the P.Datar College of Commerce. And he came there to deliver a lecture at the P.Datar College. I was mesmerized by his talk for 45 minutes, and thereafter I kept attending all his lectures at Bombay because I was there till 76. And I'm also one person who's attended his lectures at the Brabourne Stadium with 1 lakh people attending the budget lecture. It is something which can't be described unless you've seen it in person. Subsequently, when I wrote my excise book, I asked him to write a foreword, but he said he had no time, but he'd write a letter of commendation. But that didn't happen. But then I interacted with him a couple of times, I met him a few times and so on, but our relationship was not close. I just knew him as a senior lawyer and met him, say, 4, 5, 6 times. But I was very much in touch with the Forum of Free Enterprise, and with Mr. Pai, who perhaps spent more time with Palkhivala than anybody else except Mrs. Palkhivala. He accompanied him on all the tours and travels, and I used to always ask him about Palkhivala and what made the man tick. And right from my young days, I was always fascinated by one question: what makes one person reach stratospheric levels of achievement? What makes one person achieve so much more than the other? And it so happened that just 3 months before he passed away, I was in Bombay to do a case for Vico Vajradhanti. The question was whether Vico turmeric toothpaste is Ayurvedic or not. My wife is always shocked at why we are spending so much time on whether it's Ayurvedic or not Ayurvedic and so on. But this is a matter of life and death for the client. So I spoke to Mr. Pai. I said, can I come and see Mr. Palkhivala? Because earlier I used to go to meet, I used to go to Bombay House and say hello to him. So I said, can I go and see him? He said, no, Arvind, he's in a very, very bad position, or better that you don't see him at all. This happened in October and he passed away in December. In Madras, 7 of us started the first Palkhivala Foundation, and a month later they started the Palkhivala Memorial Trust in Bombay with Mr. Surabji and Mr. Maligam and so on. After he died, the Memorial Trust requested M.V. Kamath to write the biography of Palkhivala and requested Mr. Sorabji and me to write the life of Palkhivala in the light of his cases. To put it briefly, we were supposed to chronicle his legal journey from the beginning till the end. So I was given the task, Mr. Sorabji and me, to do the legal thing, and Mr. Kamath. Of course, Kamath's book came first. He's a full-time journalist. I took much more time, and I'm told that most students in Sastra University have a copy of the book which we wrote, called The Courtroom Genius. All. And this book was released in 2012 by Justice Kapadia, who gave the Palkhivala Memorial Lecture in January 2012. It took me 7 years to write the book because part-time, but the writing of the book was a fascinating, enriching, enlightening experience. I had the opportunity to interview almost all the people who work with him, his colleagues, his juniors, senior judges like Justice Chandrachud, Justice Venkat Chalaya, Justice Ranganathan, all those before whom Palkhivala appeared. I had the chance of interviewing, and I still got those tapes. And what fascinated me was, how did this man do so much? If you read the book by Major General Nilendra Kumar on Palkhivala, you'll find in the appendix, he has said that he did something like 345 or 350 cases, important cases in the Supreme Court. So from 1950 to 1995, he stopped coming after 95. In 45 years, the man has done 350 important cases, which is a record of 7 cases per year, which is something phenomenal. And it so happened that when I was just finishing the book, I came across Malcolm Gladwell's book, Outliers. I don't know how many of you read the book, Outliers. And he said that what makes one person reach the level of, say, M.S. Subbulakshmi or Ravi Shankar, what makes the other person a person who's at a lower level, and finally a person who's just perhaps playing music in the local village or something. And the answer, according to Gladwell, was 10,000 hours of deliberate practice. He said that it takes 10,000 hours to master a skill. So those of you who are lawyers, he said that there's a gentleman called Andrew Erickson who did studies in Berlin, and he found that the best violinists simply practiced more, that's all. The Beatles simply practiced more. They were in Hamburg and they were singing 8 hours a day, and that's how they developed their skills. So he said there's nothing very great about it, it's just that 10,000 hours of deliberate practice. And when I saw his life through interviews, I found that was the fundamental cause. So those of you who are going to achieve mastery must complete 10,000 hours of deliberate practice. He puts it very nicely. He says not that you don't become good because you practice. He says you will become good because you practice more and more, and that's all. And they found that the top violinists simply practice more number of hours per week than anybody else. Now this was the secret to his success. And why I mention this is because all of you are young. Some of you are going to become the Palkhivalas of the next generation, and there is no other choice except work. Of course, in his case, I found that the work was of a very, very high order. I mean, working 6.5, 7 days a week. In fact, his brother told me the saddest part was he never took holidays. And he said that once in Hyderabad, they had gone for a case, and at that time, there was only Air India. There was no Indian Airlines. There was no other private airline. And that day's flight got cancelled. And they didn't know what to do. So the local lawyer said, why don't you see the Nehru Zoo in Hyderabad? And the man was so thrilled. And towards the end of his life, he said that I should have taken more holidays. That was only regret. But he worked phenomenal amount of hours. I mean, in my book I mentioned when I interviewed Arvind from 1950 to 1995, Palkhivala never entered the Supreme Court canteen. Never. He would finish his work, immediately rush back and do the next work. Behram, his brother, told me that he never went to the origin side bar library. He would start going up the spiral staircase to the tax court, finish his work, constitutional court, immediately rush back to Bombay House or his chamber and work. So that was the kind of energy. I spoke to Triti Dolly Kuka, his secretary, for many years. Sunday, she would get half a day off. 3 o'clock, she had to be at his house for dictation. Before she came in, he'll say, please take down a dictation. So his wife will say, Nani, please stop, let us sit down, let us drink a glass of water. So that was the work he had, the passion to do work. Now let me come to the topic where I've only got 25 minutes, Palkhivala and the Constitution of India. There is a wrong belief that Palkhivala was only basically a tax lawyer. I asked his brother Behram, what is the fact? He said, no. In 1950, when the Constitution first came, there were a number of cases on preventive detention. Communists were detained, and there were a lot of cases on acquisition of property. A lot of refugees had come from Pakistan. There were a lot of requisition proceedings. So he did a number of cases on constitutional law in writs in the Bombay High Court in the early 50s, apart from tax. And the luck of the man is, if you see my book, if you read that book, Chagla was the tax judge. He would finish all the appeals in the first 3 months. So 9 months, no tax work. Then the further luck was that income tax tribunal sat in the mornings and industrial tribunal sat in the afternoons. So you do tax work in the mornings and go to the industrial tribunal in the afternoon, and not many people know that he was doing extensive amount of labor work, industrial law work in the afternoons in Bombay, because he had phenomenal knowledge of accounts. Again, look at the man's thing. He wanted to study accounts. He had no money. His father had a laundry. They had no money. In fact, I don't know if you know, when he wrote the first book, they didn't have money to pay the typist to type the first edition of the book. So Behram Palkhivala personally typed the entire first edition. That was the state. So they had no money. So he wanted how to study accounts. So he contacted Principal Banaji. There's a college called Master Tutorial College. It's a school, but it's called Master Tutorial College. The principal used to teach accounts. So Palkhivala used to go in the evening and learn accounts because he wanted to master accounts for taxation purposes. So now coming to his constitution, he did constitutional work in the beginning. And if you see from 1950 to 1965, the records, he has appeared in 2-3 important cases. One is F.N. Balsara's case on the prohibition law. And he appeared in the RMD Chamarbagwala case, which is on the prize-winning lottery scheme where the doctrine of severability is laid down by Venkatramaya. So that is the 2 important cases he argued. He lost the case in RMD Chamarbagwala, but succeeded. One other important case he argued was the Bombay Education Society, where they said that you can't study in English medium unless your mother tongue was English. So if my mother tongue is Marathi, I must study only in Marathi medium. Venkatrama's mother tongue is Tamil, he can only study in Tamil medium. Some silly law that was struck down by the Supreme Court. That was the 3 important cases. Now, what happened was after independence, right from 1951, the constitution was repeatedly amended. And as a student of law, 99% of the amendments came only because of the government's refusal to pay just compensation for acquisition proceedings. So you take the first amendment, you take the 4th amendment, the Bela Banerjee's case, all cases, all came in the context of right to property, compensation and so on and so forth. In 1951, Shankari Prasad's case, Supreme Court said that there is no limit on the power to amend the constitution. Under Article 368, in exercise of the constituent power, Parliament can amend anything. Now that law was the law till 1965, and by 1965, 17 amendments came, almost changing the constitution. Worst of all was this 9th schedule to the constitution, where once you put a law in the 9th schedule, you can't challenge it. So there would be a law which is struck down by the High Court, later it's put into the 9th schedule, immune from challenge. Then in 1965 came this Sajjan Singh's case. And all the sugar mills, the mines, etc. intervened in that case. And they wanted to say that, look, how long can you keep on amending? What is the role of the 9th schedule? And Palkhivala was briefed by Mr. Popat, who was the senior partner of Mullah and Mullah, to appear for a large number of mining companies and sugar companies. And Palkhivala one obsession was time. He would hate to waste any time. One joke told by J.B. Dharachandji, Palkhivala will say, item 4, how long will the case take? 20 minutes, 25 minutes, will it come after 1 hour? So Dharachandji told him, look, Nani, this is not a railway timetable. How do I know when the case will reach? Just had to wait, but he just couldn't wait. So he told Popat, I can't come to the Supreme Court and wait. When the matter is reached, you just call me, I'll rush by the early flight. Popat told him that, look, it's Gajendra Gadkar, and from the records I found that Gajendra Gadkar did not like Palkhivala at all. There was some reason he just disliked him immensely. And he said, be careful, you have to be there, otherwise he'll close the case. He said, no, nothing will happen. On the second day, when Gajendra Gadkar knew that Palkhivala was going to argue, he finished the argument and concluded the case. He said, there's no need, enough. He missed that case. What is most important is that in Sajjan Singh, 65 Supreme Court, for the first time, the judgment was not unanimous, it was 3:2. And those of you who are students of law, please read the dissenting views of Hidayatullah and Mudholkar. Hidayatullah effectively says, let's press the pause button. 17 amendments have taken place in 15 years. What are these fundamental rights? Are they a mere plaything of the majority? Can you amend it by majority prescribed in 368? Better judgment is Mudholkar, who for the first time used the word basic features. He said, are there some parts of the constitution which cannot be amended at all? And ironically, he refers to a judgment of the Pakistan Supreme Court, Fazul Haq Chaudhry. And the Chief Justice of Pakistan was a Christian gentleman called Cornelius, a great judge. He wrote the judgment saying that there are certain essential parts of the constitution which cannot be amended. Now, and ironically, Palkhivala's conference was half an hour, 40 minutes. He would not like to discuss more than that. But for this case, he had a 2-hour meeting with Popat and he said that, look, you say you can amend the constitution. Can you abrogate the constitution? Can you delete everything? If the answer is no, then there is one portion of the constitution which can't be touched. What is that portion? Basic feature. There's some core of the constitution which can't be touched. And he said, Popat, we should advance this argument. But unfortunately, he could not go. But by 3:2, for the first time, Supreme Court put a question mark. Can Parliament do whatever it wants? Is it a controlled constitution? Is it an uncontrolled constitution? Where are we going? 2 years later came the Golaknath case. And as all of you know, Golaknath went the other extreme. They said that once it is part 3, Parliament cannot touch it at all. This is it. Now what was Palkhivala's role in Golaknath? How many hours did he argue? Only 2 hours. His credit is only on prospective overruling. Palkhivala gets no credit for Golaknath. It was done by M.K. Nambiar. And very interesting point, Palkhivala was appearing ironically for the Union of India in Geneva regarding some civil aviation dispute. And he told Dada Chanji, I can come to India only for 1 day. I had to go back the same night. So he lands at midnight. Nariman and Ravindra Narayan brief him in the car. Next morning he goes to court and he argues on prospective overruling. Nariman told him, the Chief Justice Subbarao was mentioning prospective overruling. Without batting an eyelid, he said, there's a book by Julius Stone on social objectives, social justice. There is something on prospective overruling there, let's just check it. Why prospective overruling? If it was not prospective overruling, then all the amendments from 1950 would have been invalid. All the zamindari laws would have been invalid. All the land taken away would have to be given back. So the Supreme Court said, our judgment is prospective. Parliament cannot amend the constitution, affect fundamental rights hereafter. So Palkhivala's role was only on the point of prospective overruling. Now this golden period in 2 important cases, bank nationalization and the Privy Purses case. after 67, Mrs. Gandhi came to power on the platform of socialism. And at that time, they said that the public sector must have the commanding heights of the economy. Just 2 days before Parliament, she issues an ordinance nationalizing 14 banks. Now why 14? Why not 16? Why not 12? They put a cut-off limit. Any bank having more than 50 crore deposits is a large bank. Just imagine how the rupee is, what is gone now. So if you have more than 50 crore deposits, it's a large bank. So 14 banks had more than 50 crores, they were nationalized. He challenged it. And I must tell you one thing, if you read, because I had the chance of reading the judgment more than once, as students of constitutional law, students of law, bank nationalization lays down 2 important principles. One, it overrode the A.K. Gopalan theory of fundamental rights being mutually exclusive. He said, no, they must all be they must be read together. So mutual exclusivity was abandoned in bank nationalization. And the second very important test which you must not forget is the object and effect test. For the first time they said, see the effect of the law, not just by what is the object. Earlier Gopalan said, it doesn't matter what the consequences, but Supreme Court said, no, you must see what is the effect. And let me tell you, in bank nationalization, Palkhivala lost every point. Ordinance was upheld, nationalization was upheld, everything was upheld. Why did he succeed? For the simple reason that the compensation provisions were so ridiculous. In the compensation provision, if I nationalize Bank of India's assets, the value was so low, there was no allowance for the debts of the bank, only assets will be taken. Not only assets, suppose I take a house, the building of the bank, they will see what is the rent paid. 12 times the rent is the capital value. So if your house in, say, Trichy is, you're paying 5,000 rupees rent per month or 60,000 per year, 7.5 lakhs is the value of the house. House may be worth 50 lakhs, no 7.5 lakhs. The killer was, after giving some pittance of a compensation, the Act said, you will get this money after 10 years. They'll give you bonds now. First of all, your 100 crore property will get 2 crores and the 2 crores will come after 10 years. That was why it was struck down. Now we come to 1971. So his role in the constitution was to get out this A.K. Gopalan and also get this object effect theory. Now we come to what I may regard as the most shameful thing in the history of our constitution, abolition of the privy purses. If you get a chance, I'm sure you'll have the Constituent Assembly debates. Apart from the debates, please read, all of you youngsters, please read B.P. Menon's book, Integration of States. As all of you know, the moment independence came, we had the Indian Independence Act 1947. All the princely states, if you take statistics, we had 555, very nice number, 555 princely states. They had 28% of the area and 44% of the Indian population. Now, all had signed concordats with the British Queen Victoria and so on and so forth. So they had recognized the paramountcy of the British Crown. Now after independence, what happens to the princes? What do they do? Where do they go? By that time, partition was clear. There's going to be Pakistan, there's going to be India, and because of Sir Cyril Ratcliffe, there's going to be West Pakistan and East Pakistan. Under the Act, each princely state had the option of either joining Pakistan or joining India. It was given to the choice of the individual rulers. Now you know Hyderabad did not go at all, it was finally taken over by a thing. In Kashmir, he took the standalone principle, Maharaja Hari Singh, then we know what happened later. But this is what happened. But the beauty is, it was V.P. Menon and Sardar Patel who persuaded the princes and said, please join India and Pakistan depending on your contiguous states, because small states can't survive alone. You can't have your currency, you can't have your international status, so that's how they joined. Now, they all agreed to join India on certain constitutional guarantees. What are the guarantees? They were guaranteed a privy purse. The highest was paid to the Nizam, 43 lakhs and something. and the lowest was paid to the Raja of Kathiawad of 192 rupees per year. The total amount of privy purses was 5 crores. Just 5 crores. What did they give up? They gave up 12,000 kilometers of railway. Surrendered 12,000 kilometers of railway. All the houses in Delhi, those of you who go to Delhi, Lutyens Delhi, you'll find Baroda House is the Northern Railway Office, Hyderabad House is the Vice President's house, Travancore House is the MRTP house. So all these houses of all the princes, Patiala House is a court. So they were all taken over. They could keep one palace, they could keep some jewelry, and the privy purses was free. Now unfortunately what happened was most of the privy princes were supporting Rajaji and the Swatantra party. And let me tell you, to the credit of Pandit Nehru, repeatedly they would plead that all these rulers are British lackeys, they are British stooges, we should not pay them anything. And there's a beautiful speech by Patel, Ashutosh Ghosh said, abolish it. Patel gets up in the assembly and says, look, let us not be petty. We have achieved United India only because of the cooperation, they've given up everything for us, let us not grudge this 5 crores, let us be magnanimous and keep it like that. Despite this promise, after independence, every All India Congress session there will be a call, abolish privy purses. Nehru finally stood up and said that let us not ever do it, but out of exasperation, Nehru wrote to the princesses, please give up your privy purses. Princess said, no, I won't give it up. And when Indira Gandhi came back, she simply abolished it. That was challenged. Now, I was told by Ravindra Narain, the petition almost got dismissed. The privy purses were abolished on midnight at Friday. Palkhivala flew to Delhi. The petition was prepared in one day, filed, brought before Hidayatullah. He was about to dismiss it. After 2 hours of admission was admitted, and 3 months later, the entire privy purses was set aside and the princes were restored. Unfortunately, they re-amended the constitution under 26 because what the Supreme Court said is, you can't abolish privy purses by an executive order. There is a constitutional guarantee. So what to do? They remove the constitutional guarantee, which according to me is a shame because if you have promised something in your constitution, then you can't give it up. There's a lovely book, there's a very good lecture by Fali Nariman, and he asked an important question. How could 1,60,000 Englishmen rule over 350 million Indians? The question put is that by Sir Arthur Trevelyan, who is a historian of Oxford University. Arthur Trevelyan asked the question, at the highest number of Englishmen in India at any given point of time was 1,58,000 or something, never more than that. In the police, in the army, in the plantations, in the judiciary, every put together, there were never more than 1,60,000 Englishmen all over India. How could they rule 350 million people? And the answer is beautifully put. The answer says they could rule for 2 reasons. They took no bribes and they kept their word. And it is a shame on a nation which does not keep its word. Now let me finish privy purses and come to the famous Kesan Bharati case. And I got only 9 minutes more, so I'll conclude. When Kesan Bharati came, they wanted to brief Palkhivala. He said, I have no time. This case is going to go on for very long. I don't have time. So Popper told him, see, you dished us a Sajan Singh's case, now you can't drop us like this. He said, no, I'm not coming, you go and brief Chagla. So they went to Delhi Gymkhana Club. All this I'm telling you about through interviews. This is not anybody knows, but just through interviews of all his friends. So they went to, Chagla used to stay at Delhi Gymkhana Club, his wife has passed away, so he used to stay in the club. So they went to Delhi Gymkhana Club to brief Chagla. In the middle of meeting, he started going to sleep. He's already old, he was 73 by that time. So Popper told Palkhivala, this case requires, I don't know how many of you follow Hindi, he says, इस केस के लिए लंबे रेस का घोड़ा चाहिए. Require a horse who can run the long distance. लंबे रेस का घोड़ा चाहिए, so नहीं चलेगा. They went to C.K. Daftari. Daftari gave a Gujarati phrase which my wife knows, which means, I do the work and somebody else earns the money, I'm not interested. Bank nationalization, Palkhivala did free, but Kesan Bharati did not do free. He earned good money for that case because he appeared for all the sugar mills and other people. So they told Palkhivala, Popper told Nani, you have to do it, you can't let us down. Case was starting on a Monday, 13 judges. He comes to Delhi on Saturday and Sunday morning they start preparing. And some interesting episodes I'll tell you of Kesan Bharati and then I'll go on to the review case. who were briefing him. Soli Sorabji, Anil Diwan, galaxy of people. At the Oberoi, Palkhivala had a suite. And he would tell them he wants research done in a particular way. And by 9 o'clock in the night, all the books had to be kept outside his door. When he got up, God knows, by 8 o'clock in the morning, they used to have breakfast together. He used to be in his pajamas. And he would have read everything and he'd ask certain questions. And he had a particular sequence of doing his argument. He'd say, this is my point. For this point, I require this book, this book, this book. For this point, I want this judgment, this judgment, this judgment. And he used to get very irritated if there was a mistake in typing and so on. Very finicky about neatness, cleanliness and so on. So one day what happened was, he was arguing his case and they found out that on the third point, the books had been left in the hotel. Panic. So, Sorabji asked Popat, where is the book? He said, I don't know, it's in the hotel. He said, go and get it now. So Popat comes out of the Supreme Court, there was no security at that time. Palkhivala's driver had gone away somewhere else, no car. He found one black and yellow taxi without a driver. So Popat got into the car, drove the taxi to Oberoi, picked up the books, came back, parked the car at Menton. Now it's not there. So that's how the case was completely saved and he could continue the matter. And finally, in Kesan Bharati also, ultimately basic structure was levied. In my book I mentioned in Kesan Bharati, it is not 7:6, it is 6.6:6.4. If you read Khanna's judgment, almost till Trichy is with the government. From Trichy to Tanjavur he comes to basic structure and that becomes the law of the country. The last mile he changes the whole thing. And because if you see Kesan Bharati's case, what is the point? 24th Amendment upheld, 25th upheld except for the last part of 31C, 26th upheld, 29th upheld, and the best joke is Kesan Bharati, Palkhivala never saw Kesan Bharati. He never met him. In fact, he never appeared for Kesan Bharati. The first case was Kesan Bharati. How did Kesan Bharati come? The Kerala High Court had struck down certain land reform laws of Kerala. Those people put it in the 9th schedule. So the lead matter was His Holiness Sri Kesan Bharati. Dadachandji found out that that case has come in the list. So he rang up Palkhivala and said, look, this case has come, this is our chance to challenge all these amendments. So he filed intervening applications and so Palkhivala is basically an intervener. He never appeared for Kesan Bharati. And Andarijana told me that Kesan Bharati rang up his friend and said, why is my name coming in the paper every day? I've done nothing. So that's the scene. Then we come to a very, very unfortunate episode in our history where Kesan Bharati was sought to be reviewed. 73 they laid down Kesan Bharati. One more thing I must tell you. Another important judgment we forget is the Bennett Coleman case, where how to control the papers. So the government said no paper can have more than 6 pages. Just imagine, today the fashion supplement is 9 pages. So he said no paper can have more than 6 pages. If you want more than 6 pages, you must go to the government for permission. Then national paper, regional paper, size, etc. Like, typical bureaucratic control. So Palkhivala argued saying that this is not newsprint control, it's called newspaper control. And we all say that A. N. Ray was a person who supported the judgment. In this case, it was A. N. Ray who struck it down. That's a judgment we all miss, 73 Supreme Court, Bennett Coleman. Beautifully written on Article 19(1)(a). And surprisingly, ironically, Justice Matthew said nothing wrong with the newsprint control order. So coming back to 75, emergency. Palkhivala appeared for Indira Gandhi and then returned the brief. When she arrested everybody, he returned the brief. And one book you must read is Prashant Bhushan's The Case That Shook India. A beautiful account of what happened in the Allahabad High Court and how it came to the Supreme Court. And now this is an unfortunate part and I'll conclude in just 2 minutes more. This basic structure is bothering the government. Meanwhile, after the emergency, Indira Gandhi brought out the 41st Amendment to the Constitution. What is that amendment? It said that if you are a Prime Minister, President, Vice President or Governor for 1 day, then you are immune from all criminal offences for life, past and present. So suppose I become Governor of Nagaland for 1 day, I can do anything, murder anybody, nobody can arrest me, immunity for life. That was the amendment done. So this is how it could be misused. So suddenly one fine day, and this I have interviewed Chandrachud and everything is on tape. By the time 1975 came, out of Kesan Bharati's 13 judges, 8 had retired. So new judges were there. Ray constituted a 13-judge bench for reviewing Kesan Bharati. Matter posted on Monday. Niran Day was there all ready to go. Then last minute they called Palkhivala. He came the previous night. Whom is who appear for? Ultimately appeared for some labor association or somebody because nobody has to appear for. So this is okay, he's going to appear for some labor association. And the matter started, and by all accounts in all my interviews, and it's also recorded in H.R. Khanna's book, he says in the history of the Indian Supreme Court, those 2 days were the dates of the finest advocacy ever reached. And my records tell me, my interviews tell me, that possibly equally outstanding arguments ever in the Supreme Court were Ram Jethmalani's arguments in the Kher Singh appeal and in the Antule case. So these are the 3 classic arguments of all time in the Supreme Court. So coming back to this Kesan Bharati, the matter started. So the question arose, who filed the review petition? What do you want to review? Because Kesan Bharati is over in 73, the law is, and Kesan Bharati they said, we are laid down the law, now we are sending the case back to the constitution benches to decide as per our law. So, very interesting case. Suddenly the Palkhivala said, who's appeared, who's asked for review? So, somebody said, no, we are not very sure about this basic structure, we thought we'll reconsider it. So Justice Beg told Mr. Palkhivala that why are you upset about it? We'd like to see, we don't know what's exactly the basic structure. His reply was, I can't believe that the Supreme Court does not understand its own judgment. He says nobody knows what is due process, but due process can't be applied. Basic structure will evolve from case to case, time to time, nothing wrong with that. What is wrong in doing that? Then, he again asked, who has asked for the review? Mr. Ray said, Justice Ray said, I think Tamil Nadu government has asked. And to the credit of Govind Swaminathan, who was our Advocate General, he got up and said, we have not asked for any review. J.M. Thakur got up and said, we never asked for any review. Then the other judges got, Chandrachud told me that they got embarrassed. Who's asked for this review? A review petition has to be filed in the registry, somebody has to ask for review. What is the ground of review? So that came at 4 o'clock in the evening. All the judges expressed to him that, Chief, this is not on. Who is doing all this? Nobody asked for review. He just kept quiet. Next day morning, the arguments were to continue. Ray just comes, all 13 judges assemble, and he simply gets up and says, the bench is dissolved. And that was the end of the review attempt. Such an embarrassing thing they wanted to set aside the whole basic structure argument. And this is what has happened. Then of course, Palkhivala then appeared in the Minerva Mills case, where he laid down this balance between fundamental rights and basic structure. He appeared in the Mandal case, where he was extremely harsh in the arguments. And finally, his last appearance was in the session case, election case, where according to people Justice Murli, who briefed him, he was not effective at all. By the time he had 3-4 strokes, and he was not effective at all in that particular case. And that ultimately ended this thing. But in balance, if you see what one man has done to preserve our constitution, in terms of, take the entire from Sajjan Singh, where he couldn't appear, and this, I must also tell you about this fundamental rights case, this habeas corpus case, and I'll conclude. They wanted Palkhivala to come for the habeas corpus case. He said nothing to, why you want habeas corpus? He said, how can you have a case where people's fundamental rights can be taken away? It's unheard of. After Kesan Bharati, we can't even have such an argument. He said, who are the judges? Chandrachud, Bhagwati, Beg, Khanna and Ray. He said, I have no doubt, I'm not very sure about Ray, but I'm only doubtful about Khanna. I don't know him, he's a dark horse. He said, the very words used was, he's a dark horse. I mean, I don't know what he'll do. When the judgment came, they were at the Bombay House, and that time there was telex, there was no fax. Telex message came that Supreme Court has dismissed, saying that in an emergency, all rights can be taken away, you can be shot and there is no remedy. And to the surprise of everybody, it was H.R. Khanna who was the dissenting judge, and H.R. Khanna, by virtue of dissenting, lost his Chief Justiceship. That's the 2 cases which Palkhivala missed. So in the end, I think we all owe an indelible debt of gratitude to this man. Single-handedly, one-man army, he fought the Golaknath, Privy Purses, bank nationalization, Kesan Bharati, review, Minerva, Mandal, election. Just imagine what one man can do. I think it's a lesson for all of us. And as in the book I mentioned, what Abraham Lincoln said, that the lives of great men show that if one man can do it, others with equal effort can also do it. And I really hope and pray that I see within this audience future Palkhivalas of this country. Thank you.